Major breaking news out of the United States District Court for the Southern District of New York, where there is a pending so-called assault weapon ban case challenging New York State's attempts to ban ordinary semi-automatic rifles. Stay tuned. We'll get into this development in one moment. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so. Show your love for the right to keep and bear arms. All right, folks, so you turn into the Four Boxes Diner, not just to hear what happened, right? Anyone can read a CNN article and regurgitate it back at you. That's not what I do here. I try not to do that. I want to tell you about things that I think are developing as we speak and where it's going to take us. So today I want to talk about a development in a major lawsuit in New York federal court, specifically in the United States District Court for the Southern District of New York, which encompasses New York City. But this lawsuit, which was commenced by the Firearms Policy Coalition and by the Second Amendment Foundation, along with some individual plaintiffs, was commenced challenging New York's ban on so-called assault weapons, which, as you know, is a propaganda term. What they ban are ordinary semi-automatic rifles of the sorts of things that are clearly protected by the Second Amendment. Because after all, we know from the Heller versus D.C. decision from the United States Supreme Court in 2008, that semi-automatic handguns are protected arms. That's specifically what, of course, Justice Alito writes about in Caetano in 2016, where he references semi-automatic arms, semi-automatic handguns. So how would it possibly be the case that the Supreme Court says you cannot ban semi-automatic handguns, which arguably are associated with more crime in America than all semi-automatic rifles? So how can you possibly ban semi-automatic rifles under the Second Amendment when the Supreme Court has already said you cannot ban semi-automatic handguns under the Second Amendment? You simply can't do it. Nevertheless, we still have to bring these lawsuits and win the day, because that's just how you have to do it with the anti-gun lobby out there. So what is the development in this Firearms Policy Coalition, Second Amendment Foundation case in the Southern District of New York? It's a major favorable development, as I see it, in favor of the home team. That would be the good guys, us. You see, several years ago, there was a Second Amendment lawsuit brought in the Southern District of New York that was assigned to Judge Kenneth Karras. Judge Karras is a George W. Bush appointee to the federal bench. And back in that case, which was, in 2018, when he wrote this decision, Judge Karras denied a motion to dismiss brought by the New York Attorney General's office to a Second Amendment challenge. And this, by the way, Judge Karras denied the motion to dismiss brought by the state of New York under the Second Amendment. He ruled in favor of the Second Amendment, saying that the plaintiffs that were challenging a law in New York that required the public disclosure of the names of everyone that had applied or received a gun permit in the state of New York. The rule was back then that if you apply, you basically presumptively just have to disclose the government has the right to disclose your name and your private information to the public so they can conduct quote-unquote investigations and studies to improve gun laws in the state of New York. That was the justification. But Judge Karras, applying the Second Amendment's right to keep and bear arms in 2018, wrote an extensive decision, and this was under the worst rulings, meaning the worst standard, not the good Bruin standard of text, history, and tradition. Judge Karras actually applied the old fake standard of tiers of scrutiny, which, as you know, is a metaphor or euphemism for balancing away our individual rights in the name of government power. Again, whenever you hear tiers of scrutiny, and I don't care who tells you this, I don't care what their credentials are. If you hear tiers of scrutiny, you got to understand that is a terrible thing for the Second Amendment community. That is simply a metaphor for allowing judges, government judges, to balance away our rights in the name of some government benefit or compelling state interest and to take away rights that would otherwise be ours. So if anybody says tiers of scrutiny, intermediate scrutiny, strict scrutiny, you run for the hills. That is bad for us, and I don't care who says that. If they say that, they're simply wrong. So anyway, nevertheless, in 2018, Judge Karras ruled in favor of the Second Amendment by denying a motion to dismiss when the government tried to get out from under the Second Amendment lawsuit. He denied it. He says that, yes, forcing someone to reveal their private information to the public just to be able to keep and bear arms under their Second Amendment rights sounds to him at the time in 2018 like a potential violation of the Second Amendment. Now, that case was eventually transferred to another judge, by the way, but that had nothing to do with the Second Amendment merits. So the point is that Judge Karras has already gone on the record in favor of the Second Amendment under the old terrible standard of tiers of scrutiny. And Judge Karras has just been assigned, and this is the huge news, Judge Karras has just been assigned to handle this case brought by the Second Amendment Foundation of Firearms Policy Coalition under the new Bruin standard. So as I see it looking down the chessboard, now there's no guarantees here. All judges have to make their own independent judgments. They have to assess the things. They have to apply the law and do the right thing. But the reality is this looks very favorable as I see it because you have a judge that's willing to sustain a Second Amendment claim brought by a plaintiff against this New York State government under the old terrible standard that's bad for us. I think that bodes well that Judge Karras is going to view favorably a Second Amendment claim under the new favorable standard set forth by Nyserpa versus Bruin and Heller, involving so-called gun ban cases, or arms ban cases, which this is. So that's the breaking news. It looks like the judge is going to decide this so-called assault weapon ban case in New York, in the Southern District of New York, looks like someone who will be an objective, honest broker, and not some anti-gun zealot, of which I do think you have some of those in the federal and state benches there in New York State. But it looks like they got a good draw. A George W. Bush appointee, Judge Karras, Southern District of New York. We'll keep our eyes on this case as it progresses. But right now, that's great news as I see it. And again, it's my job here at the Four Boxes Diner to try to look down the chessboard and tell you what I think is going to happen and not just regurgitate the morning's headlines. And hopefully today, I've helped do that with the story. Okay, hope you learned something here at the Four Boxes Diner. If you haven't subscribed, please do so. We'll see you again at the Four Boxes Diner.
Orders up. Table 2A.